Alright. Okay, we are once again streaming our bar study. I think audio should be okay. Let's do a little test. Testing. Okay, let's see how this sounds. Alright, cool. I think that sounds good. Let's change to the other thingy. Alright, we're literally just going to be studying because I've, lost all desire to continue not studying. That's what I was going to say. Anyway, let's just do all these subjects. Next. Does the man have a valid claim against the pharmacy? In an action by a man against the pharmacy, the man offered only the following evidence. The man took a clearly written prescription to a pharmacy. The pharmacy's employee filled out prescription by providing pills with 30 milligrams of the active ingredients instead of 20 milligrams, as was prescribed. Shortly after taking the pills as directed, the man, who had no previous history of heart problems, suffered a heart attack. Overdoses of the active ingredient had previously been associated with heart problems. Does he have a valid claim against the pharmacy? What would it be? Like respondeat superior? Is that what it's saying? The pharmacy's employee filled the prescription by providing pills. It's because a jury could reasonably conclude the man would not have suffered a heart attack. Oh, is it a causation thingy? No, it's a causation thingy. Yes, because the jury could reasonably conclude that the man would not have suffered a heart attack had the pharmacy provided the correct dosage. Overdoses, I guess. Yeah, that sounds potential. Yes, because providing the 30 milligram rather than 20 milligrams, the pharmacy sold the man a defective product. I don't know about that one, because it's like the product works fine if it's the right dosage, right? No, because the man offered no specific proof as to the pharmacy's negligence. I think there's proof, right? Because that's an employee. No, because pharmacies are not strictly liable for injuries caused by incorrect. I don't know about that one. Let's just put C. Yeah. There's sufficient circumstantial evidence to support a conclusion that the pharmacy's employee was negligent in filling the prescription and that the consequent overdose caused the heart attack. The pharmacy would be vicariously liable for its employee's negligence under respondeat superior principles. Yeah, that one's pretty, not bad. The creditor brought an appropriate action to enforce her lien against Blackacre in the buyer's hands. If the court decides for the buyer, it will probably be because a landowner owned Blackacre in fee simple, as the land records showed, when he contracted to sell Blackacre to a buyer. 2 weeks later, the buyer paid the agreed price and received a warranty deed. A week after, when neither contract nor deed had been recorded, and while the owner remained in possession of Blackacre, a creditor properly filed a money judgment against the owner. She knew nothing of the buyer's interest. But he already paid, right? So he just hasn't recorded. A statute in the jurisdiction provides any judgment properly filed shall, for 10 years, be a lien against any person against whom the judgment is rendered. The Recording Act provides no conveyance of mortgage or real property shall be good against subsequent purchasers for value and without notice unless the same be recorded. So it's just a notice statute. The creditor brought an appropriate action to enforce her lien. If the court decides for the buyer, it's probably going to be because he's a BFP, I think. The owner's possession gave the creditor... I don't think equitable conversion applies here because there's no title shift or whatever. No. I thought I was going to pick A. The owner's possession gave the creditor construct. Did he live on it? Landowner. Wait, why would that give landowner buy contracted 2 weeks later, buyer paid. Week after, Possession creditor against the owner. She knew nothing of the buyers. I think it's just D, right? What do you mean it's B? I had a feeling it would be like that, but like, what? Oh wait, because that's not BFP. They have to be. Wait, why is it not D? There is nothing that a buyer would have had notice of that is relevant to the issue because the judgment liens. Yeah, okay, I should have. I knew that. I should have considered that. Oh well. The jurisdiction follows common law, except that burglary covers structures in additions to dwellings, and the nighttime element has been eliminated. Which of any of these individuals is guilty of burglary? A woman told a man to accompany her into her friend's unlocked barn and retrieve an expensive black saddle that she said she loaned to a friend. The man accompanied the woman to the friend's barn, opened the door, found a black saddle hanging high above the ground, and climbed a ladder to reach it. He handed the saddle down to the woman, and the two left with it together. In fact, the saddle belonged to the friend, and when the friend discovered the saddle missing, she suspected that the woman was the thief. The friend used a screwdriver. The friend used a screwdriver to break into the woman's house to find the saddle. Upon discovering the saddle on the woman's kitchen table, the friend took it back and called the police. I think it's just the woman, right? Because it's not the friend, because he doesn't have the intent. Because he thinks he's helping woman get her stuff back. And the friend knows that it's her stuff, so I think it's just a woman. Yeah. Should the trial court grant the customer's motion? A security guard dressed in plain clothes was working for a discount store when a customer got into a heated argument with the cashier over the store's refund policy. Without identifying himself as a security guard, okay, that might be relevant. The security guard suddenly grabbed the customer's arm. The customer attempted to push the security guard away, and the security guard knocked the customer to the floor, causing injuries. The customer sued the discount store for battery on a theory of vicarious liability for the injuries caused by the security guard. The store filed an answer to the customer's complaint, asserting the affirmative defense of contributory negligence. The customer has moved to strike the affirmative defense. Traditional rules of contributory negligence applies. Should the court grant the customer's motion? So he didn't identify. He grabbed the arm. Customer attempted to push the security guard away. The security guard knocked the customer. Would it be because, like, he didn't know it was a guard? No, but he's privileged to act like that, right? Because if he grabbed the arm, he would be privileged to use reasonable force. Customer sued the, I'm saying, to strike, the customer moved to strike the affirmative defense. I think so, yeah. Hey, wait a second. Yeah, that's right. Wait, yeah, that's not a defense to battery. Battery is an intentional tort. That's negligence. It's much simpler than I made it out to be. Should the court uphold a defendant's privilege claim? A plaintiff sued a defendant in connection with the dissolution of a partnership they had formed to run a parcel delivery service. They had relied on a business attorney in establishing the business. After the business failed, the plaintiff and the defendant disagreed about their respective obligations. At trial, both have hired new counsel. The plaintiff calls the business attorney to testify to representations the defendant made in meetings she had with the plaintiff and the business attorney. The defendant objects to the business attorney's testimony, invoking the attorney-client privilege. Should the court? I think this is easy, right? Because if it's like two peeps and they have the same lawyer, the privilege doesn't work against each other. They relied on a business attorney. Yeah. Should the court uphold the privilege claim? No, because the plaintiff and defendant consulted the business jointly. Yeah, I think it's that. Yeah, that one's easy. May the stockbroker's attorney still file the motion to dismiss? An investor sued a stockbroker in federal court on a federal statutory claim for securities fraud. The stockbroker's attorney prepared a motion under FRCP 12B, arguing that the complaint should be dismissed because the statute under which the suit is brought does not allow for a private right of action. The day before the stockbroker served the motion, the stockbroker's attorney learned of a new U.S. Supreme Court decision that held private lawsuits under this particular statute are allowed. May the stockbroker's attorney still file the motion to dismiss? I don't think that would be in good faith, right? The stockbroker's attorney prepared a motion arguing the complaint should be dismissed. The day before the stockbroker served the motion, the stockbroker's attorney learned of a new Supreme Court that held private lawsuits under this particular statute are allowed. No, because the defendant must be raised in answer to the complaint. Not a 12B motion. Wait, what? An investor sued a stockbroker. The stockbroker's attorney prepared a motion under 12, arguing the complaint should be dismissed. No, that's fine. No, because Rule 11 prohibits bringing a motion not warranted by existing law or a non-frivolous argument for modifying existing law. I think it's that one, right? Let's just go with, yeah, I don't know. Obviously, they were trying to trick me. What is it? Rule 11 applies to every filing in federal cases, including motions. The recent Supreme Court decision caused the stockbroker's motions to no longer be based on existing law. Did the trial court's introduction violate the defendant's federal constitutional rights? A defendant was charged with and tried for murder. At trial, the defendant testified that he had acted in self-defense. The trial court instructed the jury that the defendant had the burden of proving by preponderance of the evidence that he had acted in self-defense. The defendant objected, arguing that this instruction violated the constitutional requirement that the prosecution prove that the offense beyond a reasonable doubt. At the trial, so the defendant has to prove affirmative defenses, right? Self-defense is one. And I actually do think what is it called? The burden or whatever, the standard, is preponderance. The defendant objected, arguing that this instruction violated the constitutional requirement that the prosecution prove the offense beyond a reasonable doubt. Did the trial court's instruction? I don't think it did. Due process does not preclude requiring a defendant to prove self-defense by preponderance of the evidence. That one? Yeah. The defendant is asserting that he acted in self-defense, which is an affirmative defense. Therefore, the state may require the defendant to prove self-defense by preponderance of the evidence. That one was easy too. Honestly, I'm really not that good. A lot of these questions have just been really easy. If the retailer sues the distributor for breach of contract, will it be likely to prevail? A national distributor of windows selected a retailer to sell its windows in a specified geographic area. The parties negotiated a written distribution agreement, which stated that any order for windows placed by the retailer would be binding on the distributor, only when expressly accepted by the distributor. So he makes his terms, right? You can create the terms of acceptance. For the next 2 years, the retailer forwarded orders to the distributor, and the distributor always filed the orders. In the 3rd year, the distributor accused the retailer of overcharging customers to install the distributor's windows. The retailer responded that the distributor had no control over the retailer's installation prices. When the distributor received the retailer's next order for windows, it refused to fill the order. If the retailer sues for breach of contract, will it prevail? Is this like what an installment contract is or something? Let's assume that they will prevail, like there is a binding contract because of the conduct or whatever. Yes, because the distributor's claim regarding overcharging customers is independent of its obligation to fill retailers' orders. Yes, because the party's course of dealing binds the distributor to fill retailers' orders. No, because the retailer's practice of overcharging I don't see why it would excuse it. No, because the retailer's forwarding of orders to the distributor did not give rise to an obligation. So that's basically saying that there is no D. I think they still have to. But then the difference or whatever could be settled. Let's go with D, because this is what I was Oh, interesting. The original contract explicitly stated that the distributor was not bound to fill the retailer's orders unless the distributor expressly accepted them. Absent any evidence that this condition was excused, the distributor is not required to perform. Interesting. The express condition that the distributor must accept will not prevail over any previous. Oh, okay. I guess we might as well just write that down. A condition won't prevail. What the heck is this? Oh well. I guess we'll just roll with it. How do I get rid of this? Let's see. I wonder if I should just post this stream on the subreddit. Would anyone care? Okay, let's just write it down. Okay, I guess we'll just save it. Got it. OneDrive. I think I just doxed myself. How do I get rid of this? Selection is locked. What do you mean? Did it open 2 Word documents? I'm just gonna do a new one. I don't care. There it is. I'm dumb. Don't save. Installment case. Is this an installment contract actually? I'm just gonna type in regular course of binding. And what is it that they said? An express condition of K acceptance will prevail over any previous course of dealing that arises between the parties. In a bilateral contract, each party has promised the other blah blah. The party's course of dealing is sometimes used to interpret terms of the contract. Express terms are given greater weight than the course of dealing. Express terms are given greater weight than the course of dealing. A is correct. The express provision that the distributor would be bound by an order only when expressly accepted by the distributor was a condition, meaning until that event happened, the distributor was under no obligation to perform. Absent any other circumstances excusing this condition, the distributor was not required to fill the order, even though the retailer and distributor performed for 2 years without satisfying the condition. The practice does not negate or prevail over the express term of the original K. The retailer will fail to show the distributor breach because it was acting according to the original terms. Interesting. Well, learning opportunity. It's important to get some of the answers wrong too. That way you know. You learn for the next time as well. In this action, will the mechanic obtain a judgment against the woman? A man's car sustained moderate damage in a collision with a car driven by a woman. The accident was caused solely by the woman's negligence. Let's just highlight that. The man... What was it not highlighting? Alright. The man's car was still drivable after the accident. Examining the car the next morning, the man could see that a rear fender had to be replaced. He also noticed that gasoline had dripped onto the garage floor. The collision had caused a small leak on the gas tank. The man then took the car to a mechanic who owns and operates a body shop and arranged with the mechanic to repair damage. During their discussion, the man neglected to mention the gasoline leakage. Thereafter, while the mechanic was loosening some of the damaged material with a hammer, he caused a spark, igniting vapor and gasoline that had leaked from the fuel tank. The mechanic was severely burned. The mechanic has brought an action to recover damages against the man and the woman. The jurisdiction has adopted a pure comparative negligence rule in place of the traditional common law rule of contributory negligence. Will the mechanic obtain a judgment against the woman? Probably not, right? Unless it's foreseeable. What does the zone of danger modify? Causation? No, because there's no evidence that the woman was aware of the gas leak. No, because the mechanic would not have been harmed had the man warned him about the gasoline tank. Yes, because the mechanic was not negligent in... Yes, because the mechanic was... Oh, will the mechanic obtain? Yes, because the mechanic was not negligent in failing to discover the gasoline leak himself. Yes, because the mechanic's injury was approximate consequences of the woman's negligent driving. I don't think it is. No, because the mechanic would not have been harmed had the man warned him about the gasoline tank. Would he? I think it's a causation thing, right? I don't know if I exactly like what B is saying, but I think it's generally leaning... I think the answer should be no. There's no evidence that the woman was aware of the gas leak. Is that saying the foreseeability thing? I'm just going to go with what my mind said B. It's D. Okay, wow, it really is. It is foreseeable that a car accident could rupture a gas tank, leading the gasoline to ignite and causing severe burn damage to anyone in or near the car, and the woman's negligence was the proximate cause of the accident. The manner of the accident is not determinative. The mechanic's injury was a foreseeable result of the accident. The mechanic's injury was not so removed in time and circus. Huh. Go figure. Here it is stipulated that the accident was caused solely by the woman's negligence. She owed a duty to drive in a reasonable manner. She failed to do so. It was foreseeable that individuals attempting to remedy the damage the woman caused would suffer injury in doing so as a result of the damage the woman inflicted through her negligence. That's actually what happened here. A mechanic attempted to repair. Oh, it is foreseeable that injuries attempting to repair the damage would suffer injury. Okay, I guess I can't even be mad about that one. I just didn't know. I guess if it could be approximate cause, I don't know. Which of the following have proved with most strengthened the general contractor's prospect of recovery? A wallpaper hanger sent a general contractor this telegram. Will do all paper hanging on new doctor's building. Pro owner specs for $14,000 if you accept within reasonable time after main contract awarded. Signed, the wallpaper hanger. 3 other competing hangers sent the general contractor, and we want the general contractor to recover similar bids in the respective amounts of $18K, $19K, and $20K. The general contractor used the wallpaper's hanger's $14K figure in preparing and submitting her own sealed bid on the doctor's building. Before the bids were opened, the wallpaper hanger truthfully advised the general contractor the former's telegraphic sub-bid had been based on a 4,000 computational error and therefore revoked. Shortly thereafter, the general contractor was awarded the doctor's building construction contract. The general was awarded the doctor's building construction contract and subsequently contracted with another paper hanger for the price of $18K. The general contractor now sues the wallpaper company to recover $4K. which would help the contractor win. So it's like, hey, we'll do it for 14K. Whoops, it was an error. But bro was like, dang, we'd already chose you and we just got rewarded with it. So why would they win? Probably because there's like a binding acceptance already, right? After the wallpaper's hanger's notice of revocation, the general contractor made a reasonable effort to subcontract with another paper hanger at the lowest possible price. The general contractor had been required by the owner to submit a bid bond and could not have withdrawn or amended her bid on the main contract without forfeiting that bond. Wallpaper hanger was negligently, erroneously calculating the, I don't know, so that. General contractor dealt with all of her subcontractors in good faith and without seeking to renegotiate, lower the prices they had bid. I guess this one? Because they tried to find another person at the lowest possible price and they couldn't. The general contract had been required by the owner to submit a bid bond and could not have withdrawn. What is that? If the general contractor had to submit a bid bond relying on bids from the subcontractor, those bids would generally had been held irrevocable until the general. Oh, okay. So the contractor gets the job and accepts the subcontractors. The general rule is that contracts are revocable by the offerer until acceptance by the offeree. However, there are a number of exceptions to this general rule. A contract can become temporarily irrevocable when there has been past part performance or detrimental reliance about. That's what we want, the detrimental reliance. Okay. Let's see if I can get this next one right. If both the charity and child claim the residence, to whom should the estate distributed the residence? A man died testate. The man's estate consisted of a residence as well as a significant personal property. By his duly probated will, the man devised the residence to a friend, who is specifically identified in the will. The residue of the estate was given to the stated charity. The man's friend, although alive at the time the man executed the will, had predeceased the man. The friend's wife and their child, who has a disability, both survived the man. Anti-lapse statutes. The value of the residence has increased significantly because of recent zoning changes. There is credible extrinsic evidence that the man wanted his friend to own the residence after the man's death, so the friend and his wife could care for the child there. I don't know if intent matters for anti-lapse though. There's no applicable statute. If both the charity and the child claim the resident, it should be the child, right? Because extrinsic evidence exists. Oh my god, what was that? It has nothing to do with survivorship. I think it should be the child, right? But because none of these talk about anti-lapse statutes, maybe it should be the charity. It's not an redemption thing because it's still in his house, so it has to be a lapse. Yeah. A deceased person cannot take and hold title to property. There's no applicable anti-lapse statute, which might have been. So I guess we assume there is no anti-lapse statute unless we are told otherwise. Tricky. Can the cellmate's testimony be admitted in a joint trial over the second defendant's objection? Two defendants were being tried together in a federal court for bank robbery. The prosecutor sought to introduce testimony from the first defendant's prison cellmate. The cellmate would testify that the first defendant had admitted to the cellmate tried together. Okay. The cellmate would testify that the first defendant had admitted to the cellmate that he and the second defendant had robbed a bank. Hearsay. The prosecutor asked the court to instruct the jury that the cellmate's testimony could be considered only against the first defendant. Can the cellmate's testimony be admitted in a joint trial over the second defendant's objection? Considered only against this first defendant. I don't think it has to do with that. Might be that one. It's not technically against interest because the second defendant part I don't think is that. I think it's B. Yeah, it's a little too much. Let's see one more. Better not be a paragraph. Okay, thank God. Should the court grant the motion? A federal statute bans trade with any foreign country if the U.S. does not recognize the government of that country. For many years, the U.S. refused to recognize a particular country's government because it deemed the government repressive. The president recently extended diplomatic recognition to the country, but Congress passed a second statute withdrawing that recognition. A U.S. company has sued the appropriate federal agency, seeking to enjoin enforcement of the second statute. The government has moved to dismiss the action on the ground that it involves a non-justiciable question. I guess so. Yes. The government has moved to say yes because the action involves sensitive issues. Yes, because there's no judicially manageable standard governing diplomatic recognition. Yes, because the action concerns the validity of a federal statute. No, because the political question doctrine applies only to litigation between government entities. I didn't know that. I don't know. I honestly don't know this one. I don't know anything about separation of powers. I'm gonna go that there. Validity of a inter-branch disputes involving foreign affairs are not subject to political question doctrine when they concern the validity of a federal statute. Inter-branch disputes involving foreign affairs are not subject to political question doctrine when they concern the validity of a federal statute. I guess I should write that down. Alright, here we go. Do I have a con law one already? I don't. So we create one. Con law. Paragraph. Inter-branch disputes involving foreign affairs are not subject to the political question doctrine when they concern the validity of a federal statute. Okay, let's do one more to see if I can get it right. Especially something. Oh, never mind. A college student purchased a large bottle of no-flake dandruff. Which is following would constitute a defense for the shampoo company. A college student purchased a large bottle of no-flake dandruff shampoo manufactured by a shampoo company. The box contained the bottle stated in part, caution, use only one capful at most once a day. Greater use may cause severe damage to the scalp. The college student read the writing on the box, removed the bottle, and threw the box away. The college student's roommate asked to use the no-flake, and college student said, be careful not to use too much. The roommate thereafter used no-flake twice a day, applying 2 or 3 capsules each time. Notwithstanding the label said, use no more than 1 capful per day. See instructions. The more he used no-flake, the more inflamed his scalp became. The more it itched, and the more he used. After 3 weeks of such use, the roommate finally consulted a doctor who diagnosed his problem as a serious and irreversible case of dermatitis caused by excessive exposure to the active ingredients by no-flake. These ingredients are uniquely effective at controlling dandruff. but there is no way to remove a remote risk to a small percentage of persons who may contract dermatitis as a result of applying for prolonged periods of time. Amounts of no. The jurisdiction adheres to the traditional common law pertaining to contributory negligence and assumption of risk. The roommate asserts a claim for his injuries against the shampoo company based on strict liability and tort. 3 important facts were established. The roommate misused. Okay. The roommate was contributory negligent to using his cat. Roommate was a remote user not in privity with the shampoo. Which of the following would constitute a defense for the shampoo company? The roommate was not in privity. The best defense? The roommate misused the shampoo as uncontrollably and continued to use. Good question. I mean, I guess go simple is better, right? What do you mean it was changed from the condition? Best defense against the product's liability. Okay, I see. The collector's sale of the painting was not an acceptance of the goods, which is the maximum amount of the gallery's attempt to recover from the collector. The collector bought a gallery painting correctly described in the party's contract as one-of-a-kind self-portrait by a famous artist who had recently died. The contract price was $500K in cash, payable 1 month after a truck carrier delivered the painting to the collector. The painting was damaged in transit. The collector timely rejected it after inspection, immediately notified the gallery of the rejection, and told the gallery that the painting would be available for pickup. The gallery then sold the painting to a third party. It informed the collector that it would pick up the painting within a couple of weeks. 2 weeks later, before the gallery picked up the painting, the collector sold and delivered the painting to an art admirer for $550,000 cash. After notifying the admirer about the damage, the collector sent no money to the gallery. If the collector's sale was not an acceptance of goods, what is the maximum amount the gallery is entitled to recover? I think it's D. Really? Oh, it's not a volume. Oh, it's a doing. Alright, I'm gonna stop for now. I'm getting very tired. 53%. We were doing so well at first.